a hypothetical and we're going to work on one together, but we get a hypothetical where we read the facts. And we have to make sure that when we're reading the facts, we have to make sure that's probable cause. It's not just we think. I think. We think it's the person. We think this is the suspect. We think the suspect has brown hair. No, 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 no. We need probable cause. We need some concrete facts, right, to even charge this criminal defendant at this point. Okay, so we'll look at that in a second. So this is page 401 in your book. Where's my little guy? There he is. 401, everyone. Okay, all right. Let's move right along here. So the initial appearance, let's talk about that. In most jurisdictions, the defendants are taken before a judge or magistrate soon after the arrest. Okay. During this initial appearance, the judge makes sure that the person appearing is the person named in the complaint. Oh, that's very important. Very important that the name matches the person. Fingerprints. They have to do fingerprints to make sure this is the person. The person can say their name is Sam, I don't know, Sam Smith, right? But after fingerprints, they find out there's someone else. So we have to make sure. And who's going to make sure that that name is correct? The paralegal. That the defendant matches the name. That's another thing you need to research. Make sure that the defendant has given you their true fact name. What is their name? Okay. All right. So informs the defendant of the charges again made in the complaint. And it also advises the defendant of the right to counsel. We're constantly advising our defendant. Now he's a criminal defendant. We're going to advise our criminal defendant, you have the right to counsel, right to counsel, right to counsel. That is their constitutional right. Okay. And if you can't afford an attorney, one will be provided for you, which is known as a public defender. Okay. And guess what? I talked a lot about this when we did Miranda rights. They have the right to remain silent. You guys have to understand when you are getting facts from your client, you have to ask them, did you remain silent when you were pulled over? No, I was telling them this, this, and that, this, and this. If you're not going to remain silent, expect those words to be used against you, right? Because at this point, they're just pulling you over for some, I'm just talking about if a police officer's pulling you over for a traffic violation, but it turns into more sometimes, right? So if they're pulling you over for a traffic violation, you can choose to remain silent. They're just going to write you your ticket for whatever the violation is, and that's it. But guess what happens during those situations? If the police officer's at a vehicle and they smell something coming out of the vehicle, or the person looks intoxicated, or they see something in the vehicle that is dangerous, like maybe a gun laying on the seat, all this takes place, guys. What are they going to do? They're going to start asking questions to the person in the vehicle. If that person in the vehicle decides to remain silent at that time, that's a little different. They have proof, they have probable cause, they have reasonable suspicion that something, they have a gun laying on there. You see what I'm saying? That's a whole different situation. Okay? It depends on the facts. You really have to get the story from your client. Okay? If a defendant cannot afford to hire an attorney, then there's a public defender or a member of the private bar may be appointed to represent the defendant. The defendant may be asked to fill out an application for appointed counsel. What's the difference between an attorney and a public defender? Well, the public defender is defending someone who's can't afford an attorney or doesn't want to go out and get an attorney, right? Remember, actual attorney, the difference is public defender and attorney is that the attorney is choosing to take on this person's case. Attorneys have clients walk in their office all day long. They don't have to take all the cases. They don't have to. If they come in with the contracts case and they're not comfortable in taking it because they're a criminal defense attorney, they can turn it down. When it comes to public defending everyone, the public defender can't turn down any case. If they say, we're giving you John Smith's case, you're doing John Smith's case. You don't have a choice. That's how public defender is different from an attorney. Choices, you're getting this case. Okay? All right. Bail. The judge must decide whether to set bail or release the defendant until the next hearing. Okay? Remember, there is bail too. Remember, constitutional right, though, 8th Amendment, no excessive amount of bail. If your defendant is being allegedly accused of an assault, and they're saying his bail is $1 million. Does $1 million match up to an assault? That's a little bit excessive, okay? If we have our defendant that's being accused of a homicide, right? A homicide. This means a danger to society at this point. right? Sometimes it's not no bail. Sometimes they're a flight risk, right? Depends. So you have to look at the crime and you have to look at the bail. It should not be excessive. That's an Eighth Amendment right. Okay.